Hello, great people. Welcome back to Global Happenings today. I know you're having a great time out there. All right, still looking at the issue of secret trial for Nnamdi Kanu. His lead counsel, in this case, Mike Ozekhome, senior advocate of Nigeria, has reacted about the new practice direction of the Federal High Court in respect to terrorism related cases. And we're going to be looking at his perspective and what all Nigerians have to say about it. But before we do that, if you've not subscribed to our channel, please do well hit on the red subscribe button and also on the bell icon so that you get notification anytime we publish our videos. Now, according to the news, the lead counsel to Nnamdi Kanu, pro-Biafra agitator Mike Ozekhome, has faulted the new federal government court practice direction barring journalists from covering terrorism trials. Faulting the new rule, Ozekhome said secret trial is like the gathering of witches and wizards in a coffin. Or coven. He spoke while addressing journalists shortly after a court session on Friday. The activist lawyer said the new direction were inconsistent with the Constitution. According to him, and I quote, he said, I do not believe in secret trials because Section 36 of the Constitution talks about open trials. I do not mind if they move the venue to another place that does not disturb other litigants, but I am worried about the provision that screen off journalists the fourth estate of the realm. If you stifle information, the wrong information can emanate from the rumor mill, and that is a more dangerous issue. I am against the issue of making it look like a secret trial, as if a trial is like a gathering of witches and wizards in a coven. It should be a public trial that the whole world can watch. I'm going to challenge some portion of the new practice directions as being unconstitutional. The new rule states that terrorism proceedings will be conducted in secret. The Chief Judge of the Federal High Court, Justice Soho Tehembe, has signed the new terrorism trial rule. Wow, that's a great response coming from Ozekhome, who is the senior advocate of Nigeria, standing in for Nnamdi Kanu in respect of his case with the federal government. And guess what? This issue of new practice direction that has already been signed by the Chief Judge of the Federal High Court has triggered so many reactions from Nigerians. But before I read the reactions of Nigerians, I like to look at the standpoint of Mike Ozekhome, and he's very clear on it. He said it's like the gathering of witches and wizard in a coven, and the consequences that comes with it. The consequence. We're talking about the issue of fake news. Fake news have the capacity to destroy a nation, and why would you often have fake news or fake information at flow? We have it because we refuse to make things public. Every time you make things public, it kind of shut down fake information. Every time you make all the details glaring to the public view, the public itself would fight any form of fake news. But when something happened and you shut down and or you have meetings in closed doors and all of that, be rest assured that Nigerians, and not just Nigerians alone, the people out there will want to take advantage of that loophole you've just created. And the advantage they're going to take is to rule out fake info, fake news that will, at the end of the day, worsen your situation more and more. But immediately you allowed everything to be in the open, automatically, it's going to be difficult to do that because there will be videos and there will be key media houses who will talk about it. And when they talk about it, it will align with the video that is being played out there. So it's important for us to have an understanding about the bad side of this new practice direction for terrorism related cases. They did what they did in the open and they caused so much pains to the public. They didn't do it to the federal government in the secret. Okay, they met with the president or they met with Attorney General in the secret, and they did what they had to do They did it in the public. And when they did it in the public, everyone knew about it. So if everyone knew about it and you want to try the same person, you're trying to close door to try him, nobody should know what is going on here, then there's something faulty about the sitting. There's something which is not right about it. Now, Zeomi has talked about the section which describe, the in the Constitution, which talks about open trial, and I feel that that alone should be able to disqualify some of the, new trial or new practice direction for terrorism related cases. Or what I feel, the only thing which I feel that was okay, in the new practice direction is that perimeter distance that will be created by the security operatives, so that in event of anything happening, at least they can spot it from a distance. If you say this is where all those interested in the case, this is where they have to stop, and you can stand afar off and be watching. If they try to push past or anybody want to take advantage or want to break in, you can notice it from afar and protect the litigant and everyone who is in the court. But apart from that, I think the other ones, for me personal, I'm not like, rising up against it, but I just feel that it's not right. And just going by the right way, it should be challenged, especially by constitutional lawyers. They should go in and challenge it and see to it that it does not stand, because it would not end well for us. For example, look at the issue of Nnamdi Kanu, his trial and everything. Imagine if journalists were not in there to tell Nigerians what's up. Some persons who are very good in doing that will begin to, skim out rumors, mill out rumors from different factories of their mind, and before you know, it will affect the true thing that happened in there. You understand? Most people will begin to misinterpret, what is, done out there or done in the trial. Imagine if, for example, the Bible was concealed, not seen by all men. Some few people saw it. The interpretation would have been terrible. We would have been so confused, But being in the open, everyone have the Spirit of God, and when they read through it, they know the true contents of it. You understand? So for me, I stand with Mike Ezeome in this. But then let's just look at what Nigerians have to say. Someone here says the step taken by these people is to see how they can frustrate Nnamdi Kanu and build up any form of excuse against him. I don't know what that means. Another person here says, for me, I totally reject the new practice direction. It is not democratic. It stands against the fundamental human right of those tried. If they are yet to be proven guilty of the allegation leveled against them, then it's absolutely wrong to bring issues that would make the judgment suspicious. Wow. I like to just leave it there. Go to our comment section. Let's interact. What's your standpoint on this new practice direction by the Federal High Court, especially as it has to do with the issue of secret trial? Let's interact in our comment section.